Hello, everyone, and welcome to Uncivil Law. For today's case, we got a prison guard behaving badly in pushing someone to the floor so hard that they broke a hip. This is the case of Dennis Quinnett versus Chief Linda Cooker, coming out of Georgia. In this case, we're going to learn what happened to Mr. Quinnett and whether or not he can successfully recover, either against the guard who hurt him or against the prison as a whole. So let's read this and get started. This case arises out of an altercation between Cobb County Detention Center officer Dilmus Reed and inmate Dennis Quinnett, in which Reed allegedly caused the fracture of Quinnett's hip by pushing him with two hands onto the floor of his cell. Quinnett brought this 1983 action against Reed and his supervisors and state law assault and battery claims against Reed alone. The district court denied the motion to dismiss the complaints. The district court said this could go forward. We affirm the district court's denial of qualified immunity to Reed, but reverse the denial of qualified immunity for supervisory liability. So as we've learned before, and as we will learn again, normally in 1983 cases, you can't get to supervisory liability unless you can show some policy or procedure that would make them responsible. So let's get to see what the issues are here and why they both are and are not responsible as it relates to them separately. So let's get on with this. The incident occurred at the Cobb County Detention Center, where 54-year-old Quinnett was detained in a video-monitored cell. So we have video. That's always helpful. He had recently been arrested and was in the process of being booked into the detention center. Quinnett was housed in an intake cell. Detention center officers planned to move him to the jail general population after booking was complete. While in the intake cell, Quinnett stood at a cell door for several minutes, hoping to get the jailer's attention so he could make a phone call. As Reed opened the cell door and brought another inmate into the cell, Quinnett asked for Reed's help. Quinnett can be heard saying, "Excuse me," on the video recording of the intake cell. Quinnett remained respectful and polite, never banging loudly on the cell door or window, never yelling, and never causing any kind of disturbance. Instead of helping, Reed shut the door on him. Quinnett placed his hand on the window of the cell door as it closed. He exerted enough force or pressure on the window and did not prevent the door from closing. At that point, Quinnett was not resisting any officer, not posing a threat of any kind, and not causing a disturbance. So this guy, for some reason, wanted to make a phone call. As the jailer comes by for other reasons, he says, "Excuse me." The guy ignores him, tries to close the cell door. He puts it on the window of the door, but that doesn't preclude the door from actually closing. So he's not interfering with the operations or anything, so there's no problem. After the cell door made contact with the door frame, Reed reopened it and stepped in the cell. So after the door was closed, he reopened it, even though he's already behind bars, right? Then, without warning, Reed shoved Quinnett with two hands. The shove threw Quinnett backwards, where he fell hard on the floor. He howled and curled up in pain. His hip was broken in the fall. And it's right about this time I'm very thankful that we have it on video. Because if we didn't have it on video, we could be telling a much different story. But we have it on video. So we know what happened because we have video. So we have a video. This guy wants to make a phone call. He's trying to get the attention of the jailer. The jailer's ignoring him, right? And so he's putting his hands on the window out of some sort of expression of whatever, but he's not interfering. He's not being violent. The door closes, right? So at this point, there's no problem. But then he reopens the door and shoves him to the ground. Excessive force. There's no reason to shove him to the ground. And we have it on video. So we know what happened. So there we go. So that's good. Reed walked away as Quinnett lay motionless on the floor. A minute later, he returned, attempting to drag him to his feet. So after he shoved him to the ground, he came back a minute later and tried to drag the guy to his feet. That's good news. For approximately an hour, Quinnett remained on the floor as medical staff and jailers attempted to treat him. Emergency personnel then took him to the room where he's diagnosed with a hip. So he was remaining on this floor for an hour. So that's good. Reed was terminated from his position. So the jailer was fired for this action. So, he did it wrong, and he was fired. Perhaps because for the first time it was caught on video. It was caught on video, and then jail fired him. So that's good news. But as we're about to learn, maybe he should have been fired earlier. So maybe the jail made a mistake by not firing this guy earlier, because this wasn't exactly Reed's first incident with having problems with not following the rules of being a jailer. During this investigation, Reed acknowledged that he'd used more force than necessary. This was the 12th investigation into Reed's conduct while he was working at the center. 12 times. That's great news. In 6 of the investigations, Reed was found to have violated policy. 3 of them involved the use of excessive force. Quinnett alleges the defendants were part of the jail staff, turned a blind eye to these actions. Fair enough, we did have a little bit of notice about it, despite knowledge of the violations, thus ensuring that Reed would ultimately cause serious injury. In 2 of the 3 investigations into Reed's excessive use of force, the Cobb County Sheriff Officer disciplined Reed after finding that he indeed used excessive force. So this is not the first time we've been down this road. The Sheriff Officer did not terminate him until after the incident with Quinnett. Quinnett sued Reed and the supervisors, bringing claims under 1983 against all the defendants, as well as state law assault and battery for Reed alone. The defendants moved to dismiss, claiming that they were entitled to qualified and official immunity, because, of course, they did. With their motion to dismiss, the defendant filed a copy of the video of the incident recording in the cell. So the defendants filed a copy of the video. They would have had to produce anyway, but it's interesting they filed it. The district court denied them qualified immunity because its alleged use of force violated a clearly established right. So yeah, it was clearly established you couldn't treat an inmate this way, yes. The court denied the supervisory qualified immunity and determined that they could be held liable for a constitutional violation. So the trial court at least said, yeah, both the guy who did it and the supervisors are liable. So now we're on appeal to determine whether or not that's true. Can we get to the person? Can we get to the supervisors? The trial court said yes to both. Let's see what the Court of Appeals has to say. Qualified immunity provides complete protection for government officials sued in their individual capacities when their conduct does not violate a clearly established statutory or constitutional right of which a reasonable person would have known. Qualified immunity ensures that before they are subject to suit, officers are on notice that their conduct is unlawful. An officer is entitled to qualified immunity where his actions would be objectively reasonable to a reasonable officer in the same situation. To assert qualified immunity, an officer must be acting within the scope of discretionary authority when wrongful acts occurred. Quinnett's allegations support a conclusion either at the time of incident that he was still being seized, in which case analysis of his claim under the Fourth Amendment, or his pretrial detention begun, in which case we'd analyze it under the 14th Amendment. So there's an issue here as to what his exact status was, because there's a difference between an inmate and someone who's still being in the process. So there's a question as to is he under the Fourth Amendment protection or 14th Amendment? Because there are slightly different standards. So there is an issue as to is he in, what exact status is he in? But as the court is only going to rule here, it didn't really matter in the end. We gauge whether force is objectively unreasonable from the perspective of the reasonable officer on the scene. We employ the following factors to guide our analysis: the relationship between need for the use of force and the amount of force used, the extent of the plaintiff's injury, any effort made to limit the amount of force, the severity of the security problem, and the threat reasonably perceived, and whether the plaintiff was actively arresting. Every one of these factors weighs in favor of Quinnett. So there's a multi-factor test to determine whether or not something is reasonable or unreasonable force. We have a multi-factor test. But every one of them weighs in this person's factor. He wasn't doing anything wrong. He wasn't a threat to anyone. He wasn't causing a problem. There's no particular severe need. The guy just acted completely irresponsibly, which seems consistent with what we know about him. And so let's press on and analyze more about who's liable and why. Reed, the officer who did all this, argues that even if he used excessive force, he did not violate a clearly established law. A right is clearly established when a reasonable officer would know his conduct violates the right. We conclude at the time of the incident in this case, defendants were on notice that applying force on a non-resisting pretrial detainee would violate the clear federal law. So yeah, you can't do this. You can't apply force when someone isn't resisting, yes. Our decision in Hadley establishes that a single punch to a non-resisting detainee constituted excessive force. In the case of Hadley, the detainee had previously, while under the influence of cocaine, run around a supermarket yelling and knocking items off a shelf, as one might do on cocaine. But at the time the officer punched him, he was subdued, compliant, and non-resistant. We held it where a detainee is not resisting arrest, gratuitous use of force, even a single punch, is excessive. So yeah, you can use force when you need to use force, but if you don't need to use force, you can't. And so even a single punch is gratuitous. It is not related to a need. So you can't do that. So it is excessive in that situation, even for a guy who was hyped up on cocaine. If you had come earlier and he caused a problem, you might have been able to use force. But at the time you encountered him, he wasn't resisting. Why, we don't know, but he wasn't. So, punching him at that point was not reasonable. Yes, that makes sense to me. Once a prisoner has stopped resisting, there is no longer a need for force. So the use of force thereafter is disproportionate to need. Makes sense. So now we must turn to the supervisor's liability. Whether or not the supervisor is responsible. Well, responsible. We do have a record of this guy doing a whole bunch of bad stuff. Did his supervisors look the other way? Should they have known better? What does the court have to say? We next turn to whether Reed's supervisors may be held liable for his conduct. In this circuit, a supervisor may be held responsible under 1983 for constitutional violations committed by subordinates when either the supervisor personally participated in the violation or there's a causal connection between the supervisor's actions and the violation. None of Reed's supervisors participated in the injury, yet it was just this one guy, so we look to whether there was a causal connection between the actions and the violation. The standard we employ is extremely rigorous. In other words, we're not going to hold them liable unless you really dot all the I's. So this is a fairly strict standard. We don't do vicarious liability in 1983. So you need to prove quite a lot. So what do you need to prove? You need to establish a causal connection where a history of widespread abuse puts a responsible supervisor on notice of the need to correct an alleged deprivation and failing to do so. Those deprivations must be obvious, flagrant, rampant, and of continued duration in order to provide a meaningful notice. So we require quite a lot. Here, assuming supervisors were on notice of the need to correct the behavior given the history of misconduct, they did not fail to do so. The facts alleged in the complaint show that the Cobb's County Sheriff's Office did investigate complaints and did discipline him for instances of misconduct that were substantiated. So it unfortunately is not the case that they looked the other way. They did do investigations. They did find liability. Now they continue to employ him, which seems like a mistake, but they did do some things. It wasn't enough, but they did try. So it wasn't enough to meet the standard. It is a very, very strict standard the way it's written, and they did do the bare minimum, so could have done more, but it was enough. So no liability. Let's read on. The supervisors likely could have, and as it turns out should have, done more to discipline Reed. But given the discipline imposed, their conduct did not violate the clearly established law. Here, though, the supervisors did investigate and act when they became aware of the misconduct. While reasonable minds may disagree about the level of discipline necessary to prevent further misconduct, which, given previous, excessive force seems like more might even wanted, the sanctions imposed here were real, up to and including suspension. Thus, in light of most favorable to Quinn, these claims do not comport to our case law. With the 1983 the issue, there is also a state law claim. There's state torts. There's battery. There's assault. So we also have to analyze whether or not there's responsibility for that, the state law violations. In addition to the 1983 violation, let's read on. We now turn to Quinn's state law claims. Georgia state officials and employees are immune from liability for damages under a doctrine of official immunity, except where they act with actual malice or with actual intent to cause injury in the performance of functions. So they're generally immune, but there is an exception. If they act with actual harm to cause damage, if they do it purposefully, if they do it, with the intent to cause that result, then they can be held responsible. So they do have some immunity, but, if they're purposely trying to cause pain for pain's sake, they go too far. Okay. Because it is undisputed that Reed was acting in his official capacity at the time of the incident, to overcome official immunity, the complaint must show that they acted with actual malice or the intent to cause injury. The district court correctly concluded that Quinnett sufficiently alleged that they acted with actual malice by shoving Quinnett. Under Georgia law, actual malice is deliberate intention to do wrong that does not include implied malice, reckless disregard for safety of others. So actual malice is actual intention to do wrong. And that's exactly what you allege. This person purposely wanted to cause harm to you. That is the allegation, yes. Under Georgia law, a fact finder may infer from the evidence the defendant acted with actual malice. Given the facts alleged, a jury could properly conclude that Reed acted with actual malice. We therefore affirm the denial of the official immunity as it relates to the state law claim. We affirm the district court's denial of qualified immunity and official immunity to Reed, but reverse and remand with instruction to dismiss for the supervisory liability. So that is the end of our coverage of the case of Dennis Quinnett versus Chief Lydia Coker and others. In this case, we learned that Mr. Quinnett was shoved down into a prison cell for no particular reason, and he broke a hip, causing severe damage. And he'd like to sue. And he can get to the officer who caused this harm, Mr. Reed, so we can get to him, and he can even sue him for state law claims because he is able to show that he did it with the purpose of causing harm, and so he does not get immunity. But as to the supervisors, unfortunately, no. The supervisors were well aware that Mr. Reed had done all kinds of bad things in the past, multiple incidents of excessive force, multiple violations of rules, but they apparently had disciplined him to some degree. Not enough, as it turns out, so even though they probably should have fired him earlier, They followed the bare minimum necessary, so no supervisory liability, but Mr. Reed will have to pay his due, and that is the end of our coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.